This section relates to the role of the polluter pays principle, and as we all know, the polluter pays principle is a key point in all environmental policy, and also when designing economic instruments to achieve the environmental targets. So it's definitely a key point. And I'm looking forward to hearing the presenters develop their opinions on these different aspects of this, and so we all learn something about how we can design cost-effective instruments. And I know that you will talk in general, but if you also talk about transport sector, I will be quite happy myself. First of all, I give the floor to Mr. Pedro Herrera, professor at the National University of Distance Education here in Spain, and I look forward to you, and please.
Thank you very much, Susan, and I would also like to thank Professor Marta Villar for her kind invitation to take part in this conference. The title of my presentation is The Role of the Polluter Pays Principle in the EU Harmonized Energy Taxation, and it is implicit from the viewpoint of the state aids rules. Here you are the summary of my presentation. I will go quickly through 4 points. First of all, I will ask if it makes sense the distinction between harmonized and non-harmonized environmental taxes from the point of view of the state aid rules and the polluter pays principle. I could anticipate that I don't think it makes much sense, but let's wait to my reasoning. I will repeat this question regarding primary law, secondary law, supposing that the regulation block exemption is secondary law. I hope I can say that. And then I will come back to the guidelines. Well, from the point of view of the guidelines, the structure of this panel makes total sense, because the guidelines refer to the approval of aid regarding harmonized environmental taxes, also has special rules for the approval of aid regarding non-harmonized environmental taxes. There are also several paragraphs related to incentives and to the application of the proportionality principle. By the way, the guidelines do not refer to the case law of the European Court of Justice. Well, there is a footnote with a couple of mentions. Therefore, as they are not in the guidelines, it also makes sense that somebody here in the panel will speak about case law. So Stella, thank you for doing it. But if we fall back to the Treaty on the European Functioning on the European Union, I don't think that the distinction makes much sense. Let's review the relevant principles and provisions. Well, regarding the polluter pays principle, it is true that, at least according to a literal interpretation, it does only apply to European institutions. In other words, it only applies to secondary law, and as a matter of fact, there is a number of judgments of the court which discuss the compatibility of regulations and directives with the polluter pays principle. But also it has an indirect impact on national provisions. Of course, if we are discussing if a tax national provision is discriminatory or it involves a state aid, we have to pay attention to the polluter pays principle, irrespective if the tax is harmonized or not. Then, if we look at the treaty provision on indirect tax harmonization, they are also not relevant for the question at stake. I cannot find anything in Article 113 which makes a distinction between harmonized and non-harmonized indirect taxes, taking into account the state aid's rules. Well, regarding the polluter pays, there is a provision on temporary derogations of the polluter pay principles, with it involves extraordinary costs for the public's authorities. But I don't think this provision is relevant either regarding state aids, because on the one hand it refers to public costs, not to costs of the private sector, which are subsidized, and on the other hand these temporary derogations can only be based on environmental reasons. And to finish with, if we have a look of the provisions regarding state aids, we cannot, well, to begin with, the environment is not mentioned, only heritage, cultural heritage, and it is not very clear that it has to do with environment, and at least not the Spanish or the German translation. And of course, the Council can approve state aid regarding the protection of the environment, but that is not directly in the treaty. Then let's now go to the general block exemption regulation. As we know, we have a Council regulation, which is an enabling regulation, and then the Commission regulation. Both of them are supposed not to be legal provisions, but I think, well, they are at least in a common sense, or they have binding effects at least. Well, the Council enabling regulation mentioned the aid in favor of environmental protection, and the Commission regulation is much more specific and has a very, very long list of state aid regarding protection of the environment, which can be allowed without the requirement of a previous notification to the Commission. The list is really long, and it covers, because I will come back immediately, but we could ask, where are in the guidelines, for instance, tax exemptions to further investments in the corporation tax? Because the corporation tax is not an environmental tax. Well, they are in other provisions of the general block exemption regulation. But if we go along this long list of state aids regarding protection of the environment, we can find an issue which is of particular relevance for us. It refers to reduction in environmentally taxes, fulfilling the condition of the Council Directive on taxation of energy. Well, this Commission regulation do not mention harmonized environmental taxes. It only refers to the energy harmonized taxes. And in order that these state aids do not need to be notified to the Commission, they must meet two requirements: to be allocated according to transparent and objective selection criteria, and that at least the minimum level of taxation provided in the directive is met. Okay, and then once we have gone through primary law, secondary law, let's revisit the guidelines. And Well, the provisions in the guidelines are similar to the provisions on the Commission regulation on general block exemption, but the wording is a bit different. It's not exactly the same. Although both rules were published at the same time. The guidelines distinguish between state aid within environmental harmonized taxes and within environmental non-harmonized taxes. If we read the provision in a hurry, we could conclude that there are only two different rules. But actually there are 4 sets of rules, 3 of them regarding environmental harmonized taxes. The first one refers to the Energy Taxation Directive. And in this case, the guidelines mention a simplified approach to assess the necessity and proportionality of the aid. Perhaps there is an explanation for that, but for me, it seems to be a contradiction, because if the general block exemption says that no notification to the Commission is needed, well then, why do we need a simplified approach? A possible explanation would be that this simplified approach regarding energy and electricity harmonized taxes would be an a posteriori assessment, so that the notification would not be needed. Then we have another rule regarding tax reductions in other environmental taxes not covered for the Energy Taxation Directive. And here there is also a simplified approach in order to control the proportionality. My question is, where are those other harmonized environmental taxes? Because as a matter of fact, we don't have any harmonized environmental tax within the European Union. Even the directive, and Marta has mentioned it, and Federica, even the directive on energy taxation has nothing to do, or nearly nothing to do, with environmental protection. It is true that some countries, your country, for example, has implemented environmental taxes within the room left by the directive, but the directive gives room to enact an environmental tax, but that not obliged to enact an environmental tax, not at all. And the Spanish hydrocarbon tax or the electricity tax would be good examples of that. They are not environmental taxes. They are energy taxes. If you want environmentally related taxes, but that has nothing to do with environmental taxes, in my modest opinion. But anyway, well, I don't know. Perhaps the directive is thinking in charges regarding heavy vehicles, which are harmonized. Well, perhaps that could be. Or perhaps it is wishful thinking, and the guidelines is thinking in future harmonized environmental taxes which do not exist today, but could exist before 2020. I don't think so. And then we have other tax reductions covered by the Energy Taxation Directive, but if these reductions go beyond the minimum tax level, then they need a deep assessment, the same deep assessment that other environmental non-harmonized taxes. Thank you, and that is my last slide. So my conclusions is, to be polite, the guideline distinction between harmonized and non-harmonized environmental taxes could be improved. Second one, the concept of environmental harmonized taxes included in the guidelines is an empty notion, not because the concept is wrong or is not relevant, but because there is no European harmonized tax at all, at least nowadays. And then I think the Council regulation on general block exemption should be, the Council, not the Commission, should be far more specific. Thank you very much for having me and for having patience to let me finish, Susan.
Thank you very much, Pedro. And if I may, as I'm sharing, I may say some words myself. First of all, you're quite right. I think it was the visual thinking of when you decided the GBER that there could be more harmonized taxes. I was actually there negotiating at the time, so I know. There was discussion about a waste taxation at the time, which the Commission obviously thought at that time that it would eventually come. I don't think it will before 2020. And as you were so kindly pointing out Sweden as an example, we do have CO2 and energy taxes in Sweden, and they are both covered by the ETD. They are harmonized taxes, both of them. And you were also referring a little to why are there provisions in the guidelines when there are actually provisions in the GBER. And the reason for that, as far as I understand, is that the member state always has the option to ask for a decision. It doesn't have to, you're not obliged to use the block exemption regulation. You can actually ask for a decision for legal certainty for the companies and so on. I don't think the Commission is very keen on that because it gives an additional administrative burden for them. And also for the GBER to be used with energy taxation, you need to mention that if you give an aid to biofuels, those biofuels cannot be part of a quota obligation. That's so many member states are actually using these days. That was just a few comments from my side. Anyone has a very quick question to Pedro? Or no? Then we can move on to Professor Rosas, who has kindly asked to talk about also the polluter pays principle, but in a somewhat different manner. Please, go ahead.
I have to begin to express my gratitude to Marta Villar, even if she's not in the room, and also to Pasquale and Monica for organizing this conference. And probably I have to speak almost the last one today after an exhausting day. And after hearing all the things I have heard, probably the best option would be to remain in silence. Because my topic, you have my paper and between the documents of the conference about the role of the polluter pays principle and other key legal principles in energy taxes on a state aid context. For my 10 minutes talk in the panel, Marta said to me, you have to speak about specific topic, is the polluter pays principle in the non-harmonized taxes in a state aid context. So I'll go through the guidelines and I focused my presentation on the what the guidelines says about this topic. But if we don't know, as Pedro said, it's not clear the concept of harmonized taxes. If, as Federica says, it's not clear the concept of environmental taxes, so it makes no sense this distinction, and it makes no sense the analysis of the guidelines about how the member states may affront to enact environmental taxes, energy taxes, without the risk to be declared, or tax reductions in energy taxes without the risk to be declared a state aid against as an infringement of European law. And the problem is here also because, as Pasquale said this morning, that we here are in front of too many too many legal frameworks that are in contradiction so many times, because we have the environmental law, we have the tax law, we have the competitiveness law, and all these law around the energy law and also the transport sector. So too many legal systems with different goals and with different objectives and with different concepts. So to manage all this confusion of concepts is very, very difficult. When we speak about polluter, we used to speak about polluter pay principles as the key principle in environmental law. But in fact, if we read the treaty, there are two principles: precautionary principle and polluter pays principle, both of them. So we have to work with both of them. And that is extremely important from my point of view, particularly when we read the case law. I'll leave this topic to Estela, but I'll finish my presentation with some reference to case law, precisely about the precautionary principle, about the logic of the system. Because here, through this the global general block, the guidelines and the directives, I think that the main concept is the logic of the system. When we are in front of a tax refund, of a tax reduction, of a tax exemption, we have to understand if the logic of this tax exemption is environmental or is not environmental. That is very important. And this, in the case law, in the EGC case law, are very clear. But in the guidelines, is not so clear. So we have to play with both principles, and the interpretation of these two principles playing together must be done with the rationality and reasonability principle that we are not in the Spanish law. We don't use this principle, but in the European law it's very important, and I think that is very interesting to reason with these concepts, rationality and reasonability, and with the proportionality principle that Álvaro will speak at the end of the panel. And then we have to use different sources. I don't know if it's soft law or is law and no more, but at the end of the day, the Commission used the General Block Exception Regulation and used these guidelines. So we have taken account these soft regulations, and then the cases and the law. But using the law also we have problems because we have inconsistencies between how these concepts are used by the European law or how these concepts are used by states members' national law. Here, if I translate the sense of my presentation in an image, in the framework of state aid regulations, I have to identify which one are environmental taxes. Between these environmental taxes, which one are energy taxes, and between these energy taxes, which one are non-harmonized taxes in the sense of the environmental taxes directive. That is a very particular sense, because we will see that there are another harmonization directives that there are exceptions of this concept. So thinking about that, in the middle of this circle is empty, or all this circle is the same. But we have two options. When we work with state aid analysis, we have to go with the system of reference and the comparability and selectivity. The key concept here is the system of reference, and this is very clear from my point of view in the case law. Because if the system of reference is environmental, the answer is 1. If the system of reference is not environmental, the answer is another one. Going ahead with the guidelines and the point of the guidelines that gives some criteria, the European Commission to the member states to understand when they introduce a tax incentive in an energy tax, if they could have problems with the state aid regulations or not. So the ideas, the criteria that the European Commission gives to the member states, always speaking about environmental taxes, energy taxes, non-harmonized, if this classification would be clear. So the discrimination may be objective, transparent, and non-discriminatory criteria for a maximum period of 10 years, and well targeted to undertakings mostly affected. And here they introduce this, I call it a sector-by-sector report, something similar to country-by-country report. So explaining sector by sector why the tax incentive is well targeted to the mostly affected sectors for the tax exception. And then this is a general reference for all, for the harmonized taxes or for the non-harmonized taxes. But the Commission says when we are in front of non-harmonized taxes, there would be a depth assessment of the necessity and proportionality of the aid. And here, this is a point that is, I think that is very clear for the Commission, and to understand, and that's my idea about the system of reference, about the rationality of the measure, must be clearly defined the scope of the tax reduction or the tax refund. So this is the key point. Must be clearly defined the scope. So the reason of the tax reform, of the tax refund. And Pasquale says this morning, altering the behavior of the taxpayer. So if it is not possible to understand that the scope of the tax reduction is altering the behavior of the taxpayer in an environmental logic, we are not in front. We can have problems from the state aid system. Thinking about is Julia in the preceding panel explained a extremely useful example of the Catalan tax on airplanes on the airports, the flight tax. So that is a very clear example where the scope of the tax reduction is not environmental, clearly. So applying the criteria of the European Commission, it would be declared against the state aid regulations. Then the criteria continues with non-harmonized taxes, with two analyses. First, necessity of the aid, and to understand the necessity of the aid, the Commission spreads cumulative conditions, objective and transparent choice of beneficiaries, and substantial increase in production costs because of environmental tax, and no possible be passed to customers without significant sales reductions. The three of these conditions are cumulative, so you have to demonstrate the three of them. And to analyze the proportionality of the aid, instead the conditional alternatives. The first one is beneficiaries at least pay 20% of the environmental tax, of the energy tax, and if they don't pay the 20%, there are agreements and commitments with specific targets with a time schedule, independent monitoring of the commitments, and revise it periodically and stipulate effective penalties. And these are the alternatives. But, and I finish with this point. This is the criteria of the European Commission for non-harmonized taxes in the framework of the Energy Tax Directive. But there are exceptions to these rules. If we are in front of sectors affected by the emission trading systems, there are another guidelines, there are another directive. If we are speaking about the reductions in support for renewable energies, there are another directives, there are another rules. If we are in front of investment aid for remediation of contaminated sites, there are another rules, there are another interpretation of the polluter pays principles. And we can follow with these exceptions. When we are in front of water policy, there are another directives. When we are in front of waste management policy, there are another directives. When we are speaking about energy efficiency, when we are speaking about carbon capture and storage, when we are speaking about energy infrastructures. So at the end of the day, when are we going to apply these rules? Never, never. Instead of this approach, I think that is more interesting the approach made by the Court of Justice, because the Court of Justice distinguish very often with this clear criteria under the environmental logic of the system to interpret the taxes section, to interpret the tax reduction under the logic of the system. And I give the floor now to Estela to continue with this topic about the case law, because here it's more clear from my point of view. Thank you very much.
So, Estela, have you been preparing?
Yes.
Yes. So now we'll leave the floor to Estela Ferreiro Serre, who is a lecturer at the Tax Law Department of the University of Barcelona, and she will guide us through the case law, and not the least the, I would say, ill-famous case of British aggregates.
I would like to thanks to Professor Villar for giving me the opportunity of being part of this project and being here with you in order to present some of the results obtained after a period of research. I also would like to congratulate her and her team, Javier and Monica, for the organization of this conference, as I know that it's not an easy task. And finally, I cannot start without saying thanks to Professor Pistone, who introduced me to this brilliant group of research, giving me the possibility of being part of his team of postdoctoral fellow researchers during 2 years at the International Bureau of Fiscal Documentation. So to all of them, thank you very much. The title of my presentation is The Polluter Pays Principle in EU Energy Taxation Case Law. As we all know, the Polluter Pays Principle has been introduced in EU treaties in 1986, being one of the principles to achieve a high level of environmental protection. From an economic perspective, it is a theory essentially concerned with the issue of cost allocation. On the other hand, we know that the European Commission considers energy taxes as environmental taxes, even if it can be criticized. But which is the problem that may arise with the interaction between the polluter pays principle, energy taxation, and state aid? In that regard, it should be noted that what is usually discussed in EU energy taxation case law can be divided in two big blocks. The first one, in which the discussion turns on the qualification of a tax measure as state aid in the sense of Article 107.1 of the treaty, and second one, in which the discussion turns on the evaluation of the compatibility of the tax measure made by the European Commission. As my colleague Álvaro Antón will probably deal with the second block, I will focus on the first one. So, in relation to Article 107.1 of the treaty, which are the problems that may arise when a member state introduces a non-harmonized energy tax in order to implement the polluter pays principle? Obviously, the problems are a lot, but I'm going to focus on two of them. The first problem that may arise is if the member state introduces a non-harmonized energy tax that only covers certain enterprises. These enterprises might be in a relation of competition with other ones that are not covered by the tax. Therefore, the tax might be considered an aid for the enterprises that are not covered by the tax, or in other words, the tax might be considered a negative aid. If the group of the enterprises that benefit from this negative aid can be identified, it could be said that the aid is selective, and if this selectivity is not justified, therefore, the tax would be qualified as state aid. It should be noted that the selective definition of a tax might be done or by exemptions or exclusions or with a restricted definition of the taxable event. The second problem that may arise is if the member state introduces an energy tax that covers all the enterprises, but at the same time, it can introduce an exception to this general regime. In this case, if this exception is granting a benefit to some enterprises and not to all of them, the exception might be selective, and if this selectivity is not justified, then it would be qualified as state aid. So when a member state has to introduce non-harmonized energy taxes, it has to take into account that when defining the scope of the tax, exemptions or exclusions can be qualified as state aid. But also, depending how the taxable event is defined, the tax can be considered a selective advantage for the enterprises that are not covered by the tax and therefore qualified as state aid. On the other hand, when introducing exceptions to the general regime, if they benefit only to certain enterprises, the exception can be qualified as state aid in the sense of Article 107.1 of the treaty. However, all these restrictions can be justified, among others, by the underlying logic of the tax. And when the tax is an energy tax, the environmental aim of it might be part of this underlying logic. And I say might be. The question is then, when does this environmental aim will be taken into account by the ECJ in order to justify the selective definition of the scope of the tax or the selective definition of one of the elements of its structure? To answer to that question, we will go through three different cases in chronological order in which the restriction of the benefit is located in different elements of the structure of the tax. First, the well-known Adria BN Pipeline case, in which the measure under discussion was an exception to the general regime. Second, the British aggregate case, in which the tax measures under discussion were exemptions and exclusions of the scope of the tax. And third, the 2014 ECJ decision on the German duty on the use of nuclear fuel for the commercial production of electricity, in which the selectivity of the tax was discussed because of the restricted definition of the taxable event. So let's see when the ECJ considers that the environmental purpose of the tax is a justification of the selective definition of the scope of the tax or the selective definition of one of the elements of its structure. The Adria BN Pipeline case dealt with a rebate of the energy taxes granted only to certain enterprises. The energy taxes at stake were a tax on electricity and a tax on natural gas. The rebate was given to undertakings whose activity consisted in the manufacture of goods, insofar as both taxes exceeded 0.35% of the net production value. In that case, the ECJ considered that the general regime was the rebate of both energy taxes when they exceeded 0.35% of the net production value, being the exception to this general regime to restrict the benefit only to undertakings whose activity consisted in the manufacture of goods. Among other reasons, the ECJ considered that the selectivity of this exception was not justified by the environmental purpose of the tax, as, following the words of the court, energy consumption by each of these sectors is equally damaging to the environment. Therefore, it could be said that, in this case, the effects on the environment were a key point in the decision of the court, concluding that the selective definition of the rebate was not justified by the environmental purpose of the tax. The second case that we would like to recall is British aggregates. One of the points of discussion was the definition of the scope of the British aggregates levy through a list of materials subject to the levy and others that were exempt. In that case, the ECJ considered that the environmental purpose of the tax declared in the Economic and Fiscal Strategy Report and Financial Statement and Budget Report of March 2001 was enough justification for the selective definition of the scope of the tax. This environmental purpose was defined, as you can read in the PowerPoint presentation, and what we can underline of it is that the description of the environmental aim of this levy, it seems quite precise, in the sense that we can easily identify the effects on the environment that wants to be achieved through the introduction of this tax. Therefore, it seems that when the environmental purpose of the tax is precisely defined, it has more possibilities of being considered by the ECJ as a justification of the selective definition of the scope of the tax or the selective definition of the elements of its structure. Finally, the third case is the one on the German duty on the use of nuclear fuel for the commercial production of electricity. What is interesting of this case is that we are in front of what Mata would identify as a fiscal environmental tax, or in other words, taxes which are primarily aimed at generating revenue but which may have significant effects on the environment, and not in front of an incentive environmental tax or Pigouvian tax, as it would be, in theory, the British aggregates levy. The duty at stake only had to be paid by producers of electricity that used nuclear fuel. Therefore, the restricted definition of the taxable event could be considered the basis to argue that the duty was a negative aid, as it granted a benefit to the other producers of electricity. However, in that case, the court denies the selectivity of the tax due to the fact that the tax revenues were used for the rehabilitation required at a mining site where radioactive waste from the use of nuclear fuel was stored. Therefore, even if part of the tax literature has criticized that decision, the effects of the tax on the environment are again the key for the court to consider that the selective definition of the scope of the tax is justified by the environmental purpose. So, if the initial question was, when does this environmental aim will be taken into account by the ECJ in order to justify the selective definition of the scope of the tax or the selective definition of one of the elements of its structure, the answer could be that what it seems to understand the ECJ is that the selective definition of the tax or the selective definition of one of the elements of its structure will be justified by the environmental purpose of the tax if this purpose is precisely defined, understanding that it is precisely defined when it refers to the concrete effects of the tax on the environment. Therefore, the conclusion would be that non-harmonized energy taxes introduced by member states will be in line with Article 107.1 of the treaty if the energy tax has concrete effects on the environment, also if the structure is in line with this environmental objective. This may lead to understand that the ECJ is using a definition of environmental tax more restricted than the one given by the European Commission in its guidelines. As said before by Federica Pitrone, which includes from taxes with a polluting tax base to taxes with environmental effects. This will be in line with the defense that has been done by some authors, Federica Pitrone and Professor Villar, of a new concept of environmental tax in EU law, a new concept that we support as regarding the application of Article 107.1 of the treaty. It will increase the degree of legal certainty for member states when they are designing non-harmonized energy taxes. Thank you for your attention.
Thank you very much, Estela. Any quick questions of clarification to her? No? Oh, yes, of course.
It's only indirectly related, but I would like to know your opinion on the Spanish tax on large trade stores. Do you think that it is a kind of state aid, negative state aid?
For me, the basis of, I think the European Commission is I think that the action is brought in front of the Court of Justice, and if they follow the reasoning that we've seen in these decisions, some of these taxes, they said that they were environmental ones, and however, the use of the tax revenues were not very clear where they will use it for an environmental purpose or not. So I think that the ones that didn't define very well where was the end of these tax revenues, they will definitely be qualified as state aid, and the other ones perhaps they survive.
Just have one comment about the German case on the nuclear tax. There's also another case you might want to look into. There was a similar case in October the same year, but with the Swedish nuclear tax. There was little different argumentation by the court, but the outcome was about the same.
Okay, perfect. Thank you.
Okay, Alvaro, it's only one person left. You have the non-privileged situation to speak at last at several minutes late, but please.
I apologize, but I think I can adapt my presentation in order to be more coherent with some of the ideas exposed here today. And one of the main ideas here that I heard here today is that where there are like two positions regarding, for example, the block exemption regulation. And this was raised a lot here today. There is a position who say that the block exemption regulation is too generous. Well, that's not my position, or maybe it's not completely my position. The other position is that the block exemption regulation could be an instrument in order to give more legal certainty. And I am with this one position. I think that is the role of this block exemption should be that. And this is quite related with the proportionality principle, of course, because at the end, what the block exemption regulation did do is an ex-ante proportionality evaluation. He evaluated the proportionality of a measure, but in an ex-ante way, while the guidelines do the same, do this proportionality test, but in an ex-ante way. So it's quite related, And first of all, if we speak about that, the first thing is, well, we are talking about the polluter pays principle, and the main problem that I think that we face with this principle is that according with Article 191, which reflects the polluter principle, well, even with this new treaty, the substance of the principle is not defined. It's not defined in the treaty. So, Commission use the polluter principle for address distortion of competition, prevent chronic pollution, justify the adoption of fiscal measure, or to adopt strictly liability regimes. They use the principle as independent of the situation in a one way or other way. But at the end, it's also true that the polluter pays principle is a reflection, or should be a reflection of the proportionality principle, in the sense that the cost of the pollution should be borne by the one who created it. But also, only to the extent that they contribute to the pollution, no more, no less. But when it comes for taxes and charges, we have the problem that is quite difficult to determine the exact quantity. So, in this case, the European Court of Justice say, okay, when it comes about taxes and charges, well, the polluter pays principle as a reflection of the proportionality principle has to be flexible. So, I'm not going to ask for a very, very, very narrow application of the principle. So we don't use this idea, German idea of polluter principle of a casual responsibility, in the sense that you determine who and how much he has to pay. No, we select a group that we think this is the ones who contribute to the pollution, and then we create the tax. But then when it comes to the state aid context, well, we use the polluter principle, first of all, to determine whether a measure constitutes an state aid within the meaning of Article 107. So, as an analytical tool to allocate responsibility. But also to justify a deviation for this logical. And then, when we talk about the justification of a deviation of the polluter principle, is when proportionality arises again. Because justification needs the proportionality. In principle, the principle of proportionality appears in the treaty, article, well, but not the function of the European Union, but the Treaty of the European Union, Article 5. But it's a principle, constitutional principle in some states, a general principle of administrative law, which says at the end that, well, it's a legal safeguard against unlimited use of legislative and administrative powers. That's all Article 5 content. But we say that Commission also applies, and the European Court of Justice also applies to national measures. And that's why when the Commission evaluates the compatibility of an aid, they apply the proportionality test. But they have a dual nature. On the one hand, proportionality is used to assess the policy of a European Union or a law of or directive of the European Union, and in this case, they use a narrow interpretation sometimes. For example, in the case of the common agricultural policy, the European Court of Justice has said that, well, in this case, the proportionality principle could be applied in a narrow way, in a very flexible way, because EU have a lot of discretion in this area. So they don't apply really the proportionality test as Commission applies in the guidelines or in the block exemption regulation. They only apply a manifestly inappropriate test. If the measure is too inappropriate and too disproportionate, then they reject, but it's only a very few cases. So they don't go to a very deeply proportionality assess of the measure. They don't go. And then when it comes from a national measure, then is when these general proportionality tests are applied in all the detail. Because in this case, the EU used the proportionality principle as a market integration principle, and that's one of the problem. And then is when we notice in the guidelines and in the block section of the regulation that for a measure to be compatible, they have to pass the all proportionality test. First of all, the test of suitability or test of effectiveness, or appropriateness. Second, they have also to pass the test of restrictive alternative test, also called test of necessity and subsidiarity. And even if they pass this test, the third step, they have to pass the test of proportionality in the strict sense. So they have three steps. But when EU is the one who assess, the European Court of Justice assess EU laws or EU directive, then this proportionality principle is applied in a less restricted manner. So that means that is a way to apply this principle in a more general way. So if we can apply this principle in a more general way, then we can reflect ex-ante measures in a block exemption regulation who give more legal certainty. But for that, for example, in the case of environmental taxes, we need to know what are the real effects of our environmental tax. I mean, if a tax really reduces the pollution, and I exempt some companies to this tax, but the tax still reducing pollution, then from a manifestly inappropriate point of view, the tax is the sanction is proportionate, because even if some companies are exempted, the tax still function and still reducing the pollution, which is or should be the objective. And in this case, we have to bear in mind, because that we have a lot of policies that involve, that maybe imply sometimes more analysis and more give some kind more flexibility, because we are here talking about environmental, but also security, energy supply, energy security supply. We always forget, sometimes when we talk about environment protection, climate change, we forget about the other issue of the European Union is facing, which is the security of supply. But also we have the competitiveness issue, and we have the competition issue. So there is a lot of policies and different rules in the same assessment, and sometimes maybe it's better give some kind of more flexibility in order to apply this proportionality principle. And the only way, I think, is if we can do this proportionality test and include this test in a instrument like the block exemption regulation. And well, if we talk a little bit about biofuels, after that I will be glad. Thank you.
Okay, thank you very much, Alvaro. So first, any quick questions about his presentation? And now I leave the floor open. Anyone want to catch up on some of the issues that any one of the panelists discussed, or is everyone so tired after this day of full discussions that we should leave it at it? Mikael, please. Anyone has a microphone here? Is there a microphone? Oh, yeah.
Well, I think we can't end this session without some comments here, but thank you for very inspiring interventions here. I think there was some talk there about the principles again, so I'll just make this comment that you can actually find some of those definitions if you look a bit broader than only EU legislation. And for the, I'll just say on the polluter pays principle, there's the official OECD definition, and it's actually very narrow. It's rather a no subsidy principle rather than a Pigouvian principle of externality pricing. So when you talk about the polluter pays principle, and there's a long text there from OECD, I think that's the proper source there. And also a comment about the founding principles in EU environmental law. I think actually there are three principles: the precautionary principle, the polluter pays principle, but then also the principle of prevention, meaning that pollution should be rectified at the source. So I think it's important to consider all three principles and to also to survey their implications in this context that we are discussing here about state aid. Yeah, and I think this development of case law is very interesting, and I think there are even perhaps some more recent cases that have come out that also will add to our understanding of what is meant by state aid. But thank you for these presentations.
Thank you, Mikael, for those comments. Anyone want to catch up on, comment on what Mikael said? No? Okay, you are right, of course, as always. We agree with you. No, but definitely, the OECD has done a lot of work in this, and I think it's relevant, and I'm sure all the panelists are well aware of that and will take that into account in their future assessment of this. So, I thank everyone, thank my panelists. It's been an honor to be here, sitting up here with you, and you're performing very well. Thank you very much. And of course, thanks to Marta and her team, otherwise we wouldn't be here and we wouldn't have been managing so well with having been supplied with lunch and everything. So we thank you for today and we look forward to tomorrow.